What happens when the line between victim and criminal becomes unclear? When someone says they acted in self-defense, but the court says it was a crime? And what happens when the system later discovers it may have convicted the wrong person? Today, we explore real courtroom cases that reveal how complex justice can be. Let's begin with self-defense. Did you remember the case of Marissa Alexander we discussed back day ago? If you have not watched it, go through our videos, watch, but hear the brief insight of Marissa Alexander's story before we go deep into the topic. In 2010, Marissa Alexander fired a warning shot during a domestic dispute. No one was injured. She argued she feared for her life. Prosecutors argued the action did not meet Florida's legal standard for justified self-defense. She was sentenced to 20 years under mandatory minimum laws. After appeals and public debate, her sentence was later reduced through a plea agreement. Her case raised national questions about how self-defense laws are interpreted. Then there was Cyntoia Brown. At 16 years old, she said she acted out of fear during a dangerous encounter. She was convicted and sentenced to life in prison. Years later, her case gained widespread attention. After review, she was granted clemency and released. These cases show that self-defense depends on strict legal standards. Courts evaluate: was the threat immediate? Was the response proportional? Would a reasonable person feel the same level of danger? The answers determine freedom or prison. Other cases divided juries even further. In the trial of George Zimmerman, the defendant claimed self-defense. The jury ultimately acquitted him. In contrast, Michael Dunn also claimed fear for his life. In a retrial, he was convicted and sentenced to life in prison. And in the case of Carl Rittenhouse, the jury found the defendant not guilty after arguments centered around self-defense laws and proportional force. These verdicts sparked national debates, but self-defense cases are only one side of the justice system. Sometimes, the issue is not whether force was justified. Sometimes, the issue is whether the right person was convicted at all. Consider Ronald Cotton. Convicted largely on eyewitness testimony, he served over a decade in prison. Later, DNA testing proved he was innocent. Then there was Kirk Bloodsworth, sentenced to death. Years later, DNA evidence cleared him, making him the first death row inmate in the United States exonerated by DNA. And Anthony Ray Hinton spent nearly 30 years on death row before flawed forensic testimony was overturned and charges were dismissed. These cases reveal something powerful. Justice is not only about verdicts. It is about evidence, interpretation, legal standards, and sometimes evolving science. Self-defense claims require proof of reasonable fear. Wrongful conviction cases require proof that the system made a mistake. Both show that the courtroom is not driven by emotion. It is driven by law. And the law depends on how evidence is presented, challenged, and understood. So here is the bigger question. Is the justice system working exactly as designed? Or is it constantly evolving as new evidence, new technology, and new perspectives emerge? Comment your thoughts respectfully. If you found this breakdown informative, like the video. Subscribe for more in-depth crime documentaries, courtroom analysis, and legal system breakdowns. Because understanding justice requires looking at every side of the story.